Reprobate. Philippine law requires that a will must first be allowed by the proper court before it can pass real or personal property. This means that any will must go through probate in order for it to transfer property from a testator to an heir. This has implications for a foreign will which has already been probated abroad. The law provides two options in the case of a foreign will already probated abroad. The will can either be independently probated in the Philippines, as if for the first time, under Rules 75 and 76 of the Rules of Court, or it may be reprobated under Rule 77. What is reprobate? Reprobate is a special proceeding to establish the validity of a will already proved in a foreign country. Reprobate is how a foreign court's decision on a foreign will can be given recognition and enforced in this country. Through reprobate, a will that was already proved and allowed in a foreign country, in accordance with that foreign country's laws, may be allowed in the Philippines. What are the requirements for reprobate? In a successful reprobate, the local court acknowledges as binding the findings of the foreign probate court. This necessarily involves cross-jurisdictional issues. Reprobate usually contemplates a will on properties found in more than one country. Different citizenships and different national laws are often under consideration. The process requires that the laws of a foreign country must be submitted and proven to the Philippine court, along with the foreign will itself. For reprobate, evidence must be presented showing the following. 1. The true execution of the will in accordance with the foreign laws. 2. The testator has his domicile in the foreign country and not in the Philippines. 3. The will has already been admitted to probate in such country. 4. The fact that the foreign tribunal is a probate court. And 5. The laws of a foreign country on procedure and allowance of wills. The foreign elements can make these requirements very exacting indeed. First of all, the rules require that a copy of the will and of the foreign court order, or decree allowing it, both be duly authenticated, must be filed together with a petition of the regional trial court, and that this due authentication must comply with Philippine rules of evidence. Furthermore, for a Philippine court to rule on the foreign probate's validity, it is necessary to obtain the foreign laws on procedure and on the allowance of wills upon which that probate was based. These foreign laws also have to be authenticated abroad, in accordance with Philippine rules of evidence. The requirement to prove the foreign country's laws in accordance with Philippine rules of evidence is indispensable. Proof of these laws will have to be obtained and properly authenticated abroad, in order for the petition to be granted here. This problem is somewhat ameliorated by the Philippines' recent accession to the Hague Apostille Convention on the authentication of documents. Nonetheless, it is important that the foreign documents be obtained in coordination with legal counsel as early as possible so that he can review their sufficiency before the petition is even contemplated. What are the effects of reprobate? When the will is allowed, it shall have the same effect as if originally proved and allowed here in the Philippines. The scope of the executor's or the administrator's authority shall extend to all of the testator's estate in the Philippines. After payment of the estate's debts and the expenses of administration, the estate shall be disposed of in accordance with the will. Where should a case for reprobate be filed? Assuming the deceased was not a Philippine resident, then the case should be filed at the regional trial court of any province where he had property. The RTC, which first assumes jurisdiction over an estate, shall exercise this authority to the exclusion of all other courts. Who should be given official notice of a reprobate case? Reprobate has notice requirements identical to those of regular probate. After the petition is filed, the court will calendar the case for hearing. The order setting the case for hearing must be published in a newspaper once a week for 3 weeks. The court shall also send notice of the hearing to the named or known heirs of the deceased through mailed or personal service. The same notice will be sent to the executor of the will. Why choose reprobate? Given their similar procedural requirements, it is fair to ask why a petitioner should choose to submit a will for reprobate rather than probate. There can be good reasons for this choice. They bear on the practical distinctions between the two. Probate is a special proceeding to establish the validity of a will in the Philippines. This requires evidence to present the will's due execution. Probate takes up questions not only of authenticity, but also a host of others such as whether the will was executed under duress, the influence of fear, threats, or if it was procured through undue and improper pressure and influence on the part of the beneficiary or of some other person for his benefit. These require the presentation of evidence through witnesses competent to testify on the facts. Presenting such evidence to a Philippine court can be problematic in a case where the testator or the witnesses may be based overseas, notwithstanding that the rules allow the taking of depositions. Reprobate can offer a way to avoid these. It is essentially a way of recognizing a foreign court's already rendered judgment on probate. It also avoids having to relitigate the probate already accomplished in another country. Reprobate can also be advantageous in a case where the deceased was not a Filipino citizen. There are limitations on the disposition of a Filipino's estate, which need not apply to a foreigner. Because inheritance to his estate is governed by his national law, a foreign testator is not bound by the legitimate requirements which reserve portions of his estate to heirs designated by Philippine law. The legitimes guaranteed to the heirs of a Filipino are not binding on a foreign testator. However, the foreigner's law has to be submitted to the Philippine court to ensure that his law is actually applied. Otherwise, the processual presumption that a foreign law not properly pleaded and proved is presumed to be the same as or our local or domestic internal law may be applied upon the estate. A petitioner should submit the duly authenticated foreign laws even in a probate proceeding. This means that, since the problem of authenticating foreign law has to be traversed in either probate or reprobate anyway, the latter can be the more practical option of the two. When foreign elements are involved, reprobate can be the more efficient way for beneficiaries to settle and secure the administration of an estate in the Philippines. Thank you for watching. For more videos, you can watch us on this channel. For more content and online consultations, you can find us on lawyerphilippines.org.